Federalist 80, Part 3. We'll start with paragraph 7. On the screen, I have the cover of a book by Jack Rakoff, R-A-K-O-V-E. He's written a short biography of James Madison. It's the Library of American Biography. This book has excellent bibliography. It's a short book. It's a good book on the life of James Madison. And at the end, he does recommend a few good books. So I thought I'd just show it to you. As you know, I have mentioned his name many times. I've said just read his books if you can, or if you can't, watch some of his lectures. So let me start with paragraph 7. The power of determining causes between two states, between one state and the citizens of another, and between the citizens of different states, is perhaps not less essential to the peace of the Union than that which has been just examined. History gives us a horrid picture of dissensions and private wars which distracted and desolated Germany prior to the institution of the imperial chamber by Maximilian towards the close of the 15th century. And informs us at the same time of vast influence of that institution in appeasing the disorders and establishing the tranquility of the empire. This was a court invested with authority to decide finally all differences between the members of the Germanic body. He's referring to Federalist number 19, and he's actually talking about the fact that Germany was divided into 10 districts, and as long as they did not have a good federal system in place, there was always wars and dissensions and disagreements, and no uniform laws to be called of. And that's why in this beginning of this paper we talked about one of the important things about the federal judiciary and its function is uniformity of understanding of the law. That's why at the end of the day you need a Supreme Court to settle the cases so that there will be a uniform understanding of what the law is supposed to be. See, in Federalist number 19, let me just quote the lines that he's talking about. The impossibility of maintaining order and dispensing justice among these sovereign subjects produced the experiment of dividing the empire into 9 or 10 circles or districts, of giving them an interior organization, and of charging them with the military execution of the laws against delinquent and contumacious members. He keeps on going. He says we got to learn a lesson from places like the old confederacies, like we've talked about. So that's why we're talking about uniformity of understanding of the law in this paper. The next paragraph says, method of terminating territorial disputes between the states under the authority of the federal head was not unattended to, even in the imperfect system by which they have been hitherto held together. This is another reference. He actually mentions it in Federalist 22, that are the Constitution we live under now, the Articles of Confederation, does not even say anything about judiciary. And that's why we're having all these problems. And here pretty soon he's going to give the example of, we talked about this before, what was happening between Connecticut and Pennsylvania. There's always a territorial dispute, and I think this was talked about in Federalist 7. These territorial disputes, if we don't have a federal judiciary, if we don't have a national court system, these will lead to wars between the states. It says that's another reason we've established the federal judiciary the way we have, and that's why we have the Supreme Court. So let me read this again. A method of terminating territorial disputes between the states under the authority of the federal head was not unattended to even in the imperfect system which they have been hitherto held together. But there are many other sources besides interfering claims of boundary from which bickering and animosities may spring up among the members of the Union. To some of these we've been witness in the course of our past experience. It will readily be conjectured that I allude to the fraudulent laws which have been passed in too many of the states. When he says fraudulent laws, he's referring to these paper money laws and them different states just printing money, even though it was going to be worthless as early as soon as it was printed. He says they were doing all these stupid things and making the workings of the government very difficult, as well as getting people to lose their faith in their government. That's one of the reasons in the federal constitution we say no state is able to print money anymore. And though the proposed constitution establishes particular guards against the repetition of those instances which have heretofore made their appearance, yet it is warrantable to apprehend that the spirit which produced them will assume new shapes that could not be foreseen nor specifically provided against. Whatever practices may have a tendency to disturb the harmony between the states are proper objects of federal superintendence and control. So we have to always have a federal system, so problems will arise between the states that we can't think of right now. We can't name them right now. We can't exactly say what it is. That's why we need a federal judiciary to be able to bring these differences and misunderstandings to a peaceful termination. It may be esteemed the basis of the Union that the citizens of each state shall be entitled to all the privileges and immunities of citizens of the several states. And if it be a just principle that every government ought to possess the means of executing its own provisions by its own authority, it will follow that in order to the inviolable maintenance of that equality of privileges and immunities to which the citizens of the Union will be entitled, the national judiciary ought to preside in all cases in which one state or its citizens are opposed to another state or its citizens. To secure the full effect of so fundamental a provision against all evasions and subterfuge, it is necessary that its construction should be committed to that tribunal which, having no local attachment, will be likely to be impartial between the different states and their citizens, and which, owing its official existence to the Union, will never be likely to feel any bias inauspicious to the principles on which it is founded. So it just makes sense that states are going to have problems come up amongst themselves or their citizens. So it's best to have a third party, a neutral place to solve these problems out. And what better place than the federal judiciary, federal courts, and as a court of last resort, the Supreme Court. The following short paragraph, the fifth point will demand little animadversion. The most bigoted idolizers of state authority, those who are so ignorantly stuck to the idea that the state has to have all the authority. have not thus far shown a disposition to deny the national judiciary the cognizance of maritime causes. These so generally depend on the laws of nations and so commonly affect the rights of foreigners that they fall within the considerations which are relative to the public peace. The most important part of them are, by the present Confederation, submitted to federal jurisdiction. I'll stop here, but this is where he starts talking about that case between Pennsylvania and Connecticut and how you have to finally have a neutral partner to work out a good solution, an unbiased and fair solution between states or between citizens of different states.